Well, a very good evening, and a very good evening from London. Welcome. Welcome to you all from whatever time zone you happen to be in. And I'm delighted there are so many time zones and so many nationalities represented in the audience, people continuing to join, even as I say these words of introduction. My name is Mark Hill. I am the chairman of the Ecclesiastical Law Society, which has organised this evening's lecture with the collaboration and the support of Villanova University. My particular thanks go to Professor Michael Morland, who first planted the seed of today's lecture and from whom we will hear at its conclusion. I expect many of you, like me, will have cursed Zoom and similar platforms for their cumbersome dehumanizing of our interactions over the past 8 months. But today I found myself offering up a small prayer of thanks as I realized it would have been impossible to find an auditorium large enough to house the many people who have booked to attend. And the interest in today's lecture came as no surprise. Lord Williams is recognized throughout the globe as a theologian and poet. Uniquely, he served successively as primate of 2 Anglican provinces, the Church in Wales and then the Church of England, the latter carrying with it the leadership of the Anglican Communion worldwide. He then returned to academic life as Master of Magdalen College, Cambridge. And unlike his predecessor, Thomas Becket, the subject of this evening's lecture, Rowan survived to enjoy a well-earned retirement and is now settled in his beloved Welsh homeland. During his time as Archbishop of Canterbury, Rowan was patron of the Ecclesiastical Law Society and consistently emphasized the importance of ecclesiastical law and canon law in the life of the Church, enabling and facilitating its mission and its witness. In the public square, Rowan spoke with conviction and insight on issues of church and state and their legal regulation. Characters in history are usually recollected for the lives they led. In stark contrast, St. Thomas of Canterbury is primarily remembered for his death, its location, its circumstances, and its brutality. In a few days, on the 29th of December, we will mark the 850th anniversary of Becket's murder in Canterbury Cathedral, and we are grateful to its current dean, Robert Willis, for partnering with us in today's lecture. There will be an opportunity for questions at the end. In the introduction, Russell has explained how they can come either through the chat box or by use of the electronic hand facility which we have with the Zoom platform. And I will do the best I can to enable as many of you as possible to respond to Rowan's lecture. He has taken for his title, Saving Our Order, Thomas Becket, Henry II, and the Law of Church and State. A more propitious combination of speaker and subject is hard to imagine. And it is my privilege and my pleasure to introduce Rowan Williams.
Thank you very much indeed, Mark, and thank you to the ELS for the opportunity of addressing you on this occasion. My title is taken partly, of course, from a formula which became very familiar in Thomas Becket's life. He insisted on qualifying his oath of allegiance to the king with the phrase saving our order, or saving the rights of our order. That is, he was prepared to grant loyalty to the sovereign, with the reservation that the rights of the order of bishops should be preserved, that he should not be obliged to do anything that infringed those fundamental legal liberties. But his life and his death are still very often read through the lens of a particular kind of narrative, a narrative about consolidating the rule of law. In this narrative, the dominant issue is the fate of what are usually called criminous clerks, the question of whether clergy were liable to punishment by the same legal system as was applied to other citizens. On this account, Becket is resisting the universality of civic identity and obligation, civic identity under a single legal system applicable to all. And in a rather simple, progressive historical framework, Becket seems to be on the wrong side in a story that extends from Henry II to Magna Carta and habeas corpus, the steady process of establishing the access of all citizens to legal redress for injury on an equitable, comprehensive basis. Now, this is a set of issues that still resonates in the minds of some commentators, when, for example, the question arises of the relation between the disciplines of particular religious bodies and the law of the state. When the Church of England's Synod turned down a first attempt to provide for the ordination of women as bishops, there was talk in a few quarters of obliging the Church to comply with employment legislation about gender equality. Similar ideas were floated during the debates more recently about the legalization of same-sex marriage. In the early 2000s, issues arose about public financial support for Catholic adoption agencies which refused to place children with same-sex couples. Scandals about the sexual abuse of children in several Christian confessions have highlighted the risks of religious authority effectively creating immunity for gross offences by restricting punishment to the level of the discretionary and pastoral. And there is an ongoing discussion about the scope of Sharia law in non-Muslim societies, and whether the observance of Muslim law is tantamount to removing certain citizens from both the duties and the protections of the law of the land. Some of you will remember that I got my fingers burned intervening on this particular subject some years ago, but I'm not going to reopen that particular question tonight. But seen from the perspective of these contemporary debates and anxieties, it's not difficult to read the Becket controversy much as earlier English historians did. A struggle between a rational legal universalism, one law for all, and the claims of an alien presence within the real body politic, claiming immunity, special treatment. There have been many good biographies of Thomas Becket, but John Guy's biography of 2012 is particularly strong in its resolute refusal of this simplified interpretation of the Becket controversy. John Guy is clear that the confrontation wasn't between a monarch who aspired to a universal codified charter of legal rights and liberties on the one hand, and an obstinate defender of arbitrary privilege on the other. And he rightly places the question of criminous clerks, criminal clergy, in the context of a range of other problems that are rather less patient of a simple Whig reading of history. Earlier scholars had argued the detail of this, though without making much impression on the textbook version. We look at Adrian Lane Poole's discussion as long ago as the 1950s, the work of Beryl Smalley and James Alexander, for example. But in this brief reflection on this occasion on Becket's career and its reception and interpretation, I don't intend to add anything to the scholarly discussion among historians, which is beyond my competence in any case, but simply to draw out some of these complexities, and to note how differing approaches to the very purpose of law and punishment need to be factored into our understanding of the conflict. But a word of caution may be in order. If we refuse the conventional picture of Henry II's legal agenda, that is, Henry as a defender of universal rights, legal equality, if we refuse that picture, that's not to accept an uncritical interpretation of what Becket was trying to defend, or to cast him as a modern martyr of conscience, or even a martyr for the Church's liberties in a totalitarian political order in which there's only one sovereign loyalty possible. The very concept of a civic identity governed by universally applicable law is simply not one that you can just map directly onto medieval political thinking and practice. Medieval political theorists did indeed develop notions of universal right, which ultimately and indirectly fed into the modern discourse of human rights. Don't let anybody tell you that human rights is an invention of the Enlightenment. But medieval political reality was always a site of contesting and sometimes overlapping jurisdictions. And there's no theory of a universal secular state, what Hegel called a Rechtsstaat, to organize that reality. So when clerics resisted the claims of royal jurisdiction, they weren't necessarily affirming the freedom of the church over against the state in our modern sense. They were defending what would have seemed to them a clear and identifiable source of legal authority against a less well-grounded and more arbitrary one. More of that later. Now, John Guy's biography directs our attention to one very important aspect of the controversy, and that is the role of custom in the arguments. In 1164, at the Council of Clarendon, Thomas Becket, reluctantly and under great pressure, agreed to a formula that established the customs of the realm as authoritative in respect of the immunity of criminal clerks. And notoriously, he was somewhat wrong-footed. He was almost immediately confronted with a written summary of the alleged customs of the realm, which contained prescriptions which were certainly not established customs. They represented a concerted attempt by the king to reinforce, among other things, restraint of appeals to the Roman Curia and close control over the relations of English clergy to the papacy. Now, given that the independence of church courts had been recognized in fairly straightforward terms by King Stephen's Charter of Liberties in 1136, it's not entirely surprising that Becket, with for once most of his fellow bishops in agreement with him, thought it reasonable that the concession to custom here was a risk they could afford to take. But as John Guy observes, the suspicious promptness with which the king produced a written register of customs suggests very strongly that King Henry had decided in advance what he wanted to press through on this occasion. And the very rapidity of the process indicates that he knew perfectly well that his agenda was not uncontroversial. But at the same time, as several modern historians have been at pains to note, the exact scope of the wording of King Stephen's charter isn't completely clear. It's certainly debatable whether Becket's repeated insistence that royal or local feudal courts had no jurisdiction over clerics accused of serious criminal activity, like murder, was as solidly based as he assumed. In effect, Thomas was taking up a position that was still being debated in continental European discussion of canon law about the extent of clerical immunity, rather than, as he himself repeatedly claimed, defending a fixed rule. The baseline for earlier discussion seems to have been the provision in the Code of Justinian that clerics who were convicted in a lay magistrate's court of serious criminality should first be deposed from holy orders and then handed over again to the non-ecclesiastical courts. But what was increasingly being debated was whether this infringed the principle of avoiding double jeopardy, people being tried and punished twice for the same crime. It might make sense to say that a deposed cleric could no longer claim immunity, and that any future delinquency on his part should be punished by the lay courts. But the question was whether that forfeited immunity was, so to speak, retrospective in a way that permitted the lay courts to impose a sentence on somebody who had already received an ecclesiastical penalty. Those who've most closely examined the history agree that, in practice, handing over convicted clerics after deposition to lay courts for further punishment in the case of really serious offences wasn't in itself an insoluble problem. Though it didn't help that there'd been a series of particularly scandalous cases in the years before the Council of Clarendon. Later 12th century practice suggests that the papacy was not averse to compromise on this point. And at the beginning of his primacy, it seems that Becket himself had been pragmatic about it. But the intellectual heavyweights in his circle, including especially John of Salisbury, were in favour of a more thoroughgoing approach, based on the double jeopardy argument. And Becket came to adopt an inflexible stance on the question, with the results we know. As I've hinted, he was himself on rather shaky ground in claiming that his radical version of clerical immunity was customary. But in a sense, this is the heart of the argument as it unfolded at Clarendon and afterwards. King Henry was not, in fact, committing himself to observing a definable deposit of precedent, a benign tradition of common law. He was claiming the authority to create a tradition. And part of what Becket and his colleagues were resisting was the implied freedom of the sovereign to determine not only what was and was not relevant precedent, but what was to count as custom. The underlying issue is what the sovereign power is actually accountable to. Ultimately, whether the sovereign is in any sense bound by a law not made by that sovereign, which the force of custom carries with it. But equally, Becket's own radicalism about clerical immunity could be seen by a hostile critic as a comparable strategy, claiming the sovereign right to impose a contested reading of the past. It's certainly true that the problem of immunity was not the only or the most intractable issue between Henry and his archbishop. But its importance is less to do with questions about equality before the law than with the problem of arbitrary sovereignty. As sometimes happens, Becket was unfortunate in the specific issue he chose to fight, but not without justification in the principle he discerned behind the conflict, a point I'll return to. And, ironically enough, his own arguments opened up some of the same problems about the continuity of legal practice and the accountability of positive authority to law that was more than the enactment of that authority's current immediate goals. But now all this reminds us that this was an era in which the codification of law and custom was a pervasive concern in the church. Between 1050 and 1150, the codification of canon law made notable advances. Gratian, whose work was to become definitive in this process, was roughly contemporary with Becket. The ideal of a uniform set of established protocols and practices focused on the supreme magistracy of the Pope and the Curia was establishing itself firmly in Western Christendom. In the wake of earlier 11th and early 12th century controversies in continental Europe about the rights of investiture of bishops, a far greater theoretical clarity was emerging about the notion that the Catholic Church was a kind of, to use the medieval phrase, municipalitas, a self-contained system of jurisdiction and legal claim. If Henry II was eager to have a written version of the customs of the realm, he was exhibiting a concern that his clerical contemporaries would have understood perfectly. Although the latter, the clerics, would have been working primarily with already existing texts, rather than the nebulous group memory of custom. But canon law, as the definition of the law of a self-contained polity, of course implied the legitimacy of that polity wherever it might be present. Hence the anxiety on the part of secular rulers about appeals over the head of the local reigning monarch. Rather as in the modern case of Sharia law, as popularly understood anyway, the claims of the church as a polity, a municipality with its own magistrates, was perceived as a threat to the ultimate claim of loyalty to the local sovereign. But in this period, that claim, the sovereign's claim, rested partly on the role of the medieval sovereign as the focal point of a system of land tenure and patronage. The holding of land required a profession of allegiance and commitment to certain obligations of what you would call rental duty, including the duty of supplying subsidy to an overlord in pursuit of military defense, subsidy in money or in men or both. And this too was to be an issue in the Becket controversy. Less obviously a headline question than clerical immunity, but in fact equally neuralgic. Becket was able to appeal to the example of his great predecessor Anselm, for example, who had strenuously resisted royal demands for subsidy on the grounds that the church's property was not to be alienated to lay interests. Although Anselm had done homage to William Rufus, the lands of the See of Canterbury, he rather significantly refused to repeat this with Henry I, ostensibly on the grounds that there was no need to repeat the action, but also because of the bitter dispute over subsidies demanded by the king, in which he'd already become involved. There were clear echoes of these confrontations at the Council of Northampton in the autumn of 1164, where Becket was accused of mismanaging a dispute about landholding which had been referred to the king for adjudication by the unsuccessful claimant, who received a negative judgment in the Archbishop's Court. Becket was persuaded to submit to a fine, although he claimed that he was not answerable in the king's court for his actions as Archbishop. The problem was, as the other bishops helpfully pointed out to him, that a cleric's standing as a feudal landholder was something that implicitly placed him alongside other landholders. If there were complaints about his conduct as a feudal landholder, it was rather difficult to argue that he should not be judged on the same basis as other landholders. Interestingly, on the detail of this particular case, there was widespread lay sympathy with Becket. The basic point was that a bishop was, in a significant sense, a baron among other barons as far as the laws of land tenure were concerned, and there was a clear case for his accountability on the same terms. But other barons were a little bit nervous about referring claims like this to the king. During Becket's last period of exile, many of his manorial holdings in Kent, and those of his family and associates too, were confiscated by the king and handed over to administration by rapacious local lay magnates. This, of course, meant that revenues on which the church relied for maintaining the clergy, and more generally the institutional life of the diocese, disappeared. And this was exactly what Becket had wanted at all costs to prevent when he protested at being called to answer as a landowner in the king's court. The customs, the Council of Clarendon, had laid down the king's right to utilize as he pleased the revenues of dioceses and abbeys in vacancy, a common usage which Becket himself had administered when he was Chancellor to the king. And this might be taken to imply that the normal application of church revenues to church purposes that obtained when a bishop was in office was a kind of concession, and in a vacancy things reverted to a legal norm, and the income reverted to the king. Against this, Becket and others had to argue that while the church's revenues might derive from the same system of tenure as any lay magnate, their use must be determined by ecclesiastical priorities alone and by ecclesiastical law. An important point, I'll just repeat it. The argument is that while the revenues might derive from feudal custom and feudal law on the same ticket as lay landowners, the use of revenues so devised had to be controlled by ecclesiastical norms and laws. Anselm had protested to King William II that he was bound to keep the revenues of his see intact for the sake of the poor who were dependent on the church and who would suffer most directly if new burdens were imposed. And this is itself a traditional theme associated with the recorded refusal of St. Alphege a century and a half before Becket to use the wealth of the See of Canterbury to secure a ransom for the Danes who were holding him captive, a refusal which contributed to his violent death. It's no accident that Becket invoked Alphege both in his final Christmas sermon and in his last prayers as he was killed. To read all this as no more than a self-interested fiction is to do less than justice to the ideas underlying it. The church might derive its income from a system shared with lay landholders, but the point is that the church's obligations were not simply those of feudal relations. Education, liturgy, the monastic life, and indeed a fair amount of basic poor relief and emergency capacity were built into the budget of clerical bodies. And the protection of those who did not have claims within the lay feudal system was taken very seriously by most churchmen. It's the sort of thing for which, in the Middle Ages, exemplary bishops are routinely praised by their biographers. Now, this brings us close to some of the central questions behind the various specific controversies. Clergy, you might say, in this period are supposed to be immune from the lay courts because they're answerable to different requirements. The requirements set out in the increasingly systematized body of ecclesiastical law, but also embodied in the custom of the church. That is, in the various routine practices of clerical maintenance and charitable subsidy. But there's a further significant implication. The issues around clerics guilty of serious criminality raised the question of appropriate punishment. Most such serious offences carried severe penalties in the lay courts, including death. But as John Guy puts it, quote, for Becket, the type of punishment meted out was not the point. Becket and his allies, who on this issue included some of his most consistent opponents, such as Gilbert Folliot, Bishop of London, were not critics of capital punishment as such, but they worked on the assumption that punishment for clergy was always supposed to be reformatory, even where serious offences were at issue. Hence, even for the gravest crimes, penalties were typically extended pilgrimage or confinement in a monastery, with deposition from orders as the ultimate sanction. There's some interesting light thrown on this in a recent article by the great Cambridge medievalist Rosamund McKitterick, who examines an earlier controversy which turned on just this question. This is a controversy involving 8th century Pope. A cleric who had been convicted of organizing the murder of 2 other clergy, members of the papal household, had been handed over by the Archbishop of Ravenna to the lay governor of the city for execution. And the Pope protested that he had intended to impose a penance in order to save the offender's soul, and that the Archbishop of Ravenna had acted ultra vires. There were several intriguing questions about the actual conduct of investigation and trials in both Rome and Ravenna in relation to this case. But the point raised by McKitterick that is most pertinent for this discussion is the language used to describe the petition in Rome which urged the Pope to exact, quote, vengeance, and emendatio, emendation, improvement, a term which definitely implies punishment aimed at reformation. McKittrick notes how the practice and language of the papal courts from the late 6th century onwards increasingly concerns itself with the redemption of the sinner. By the time of the case mentioned, I quote, the two ideas of reform of an offender, first by punishment and secondly by penance, were entwined in notions of justice in 8th century Rome. The conflict, in fact, is not over who has the right to try criminals' clerks. It's about the purpose of punishment. Now, it's not a very long step from this concern to a concern about the right of trial, of course. McKittrick provides a very full and very lucid discussion of the still rather hybrid character of canonical collections during the early medieval period. And she shows how both secular and ecclesiastical sources were drawn upon in providing what were basically handbooks of precedent to help bishops make decisions in their courts. We can't trace a continuous conflict over immunity, clerical immunity, because the exercise of both lay and clerical jurisdiction was enormously diverse in different localities, and you can't really find any independent theory of secular jurisdiction. The compilation of legal sources was often a matter of quarrying what were believed to be Roman authorities. The word Roman always carries a kind of aura in this connection. But those authorities were both imperial and ecclesiastical. And the point of compiling these sources was to give some framework to a variety of enactments by bishops and rulers. Behind McKittrick's treatment of the detail of this, there is the fact that Roman sources, above all the Theodosian Code and the Novellae of Justinian, belonged in a setting where the emperor's jurisdiction was the long-stop guarantee for canonical decisions in church as well as elsewhere. In other words, clerical and lay courts were not in this period parallel jurisdictions. But the history of the early medieval West comes to reflect a different set of concerns and constraints, where increasingly the pressing need was to defend clerical autonomy from being swallowed up in the custom of emergent feudal societies, with their complex interweavings of obligation. From the clerical point of view, what is at risk is the church's liberty to dispose of its property. And for this liberty to be secured, the representative of the church must be defined as outside the lay system and bound by the laws of the ecclesiastical municipalities, increasingly elaborated as a would-be coherent code administered by a hierarchical pyramid of clerical courts, at the summit of which stood the papal curia. Independence in respect of the administration of ecclesiastical property, that is, the refusal of any external claim on this, as in St. Anselm's quarrel with William Rufus, and the freedom of appeal to Rome, and by implication, freedom to travel outside the realm to wherever the curia was resident, clerics within any royal jurisdiction, were both things intrinsic to this model. Hence, the alarm created by the customs put forward at Clarendon in 1164, which explicitly sought to limit just those clerical liberties. Limit freedom of travel to the curia and to compromise the independence of ecclesiastical property by assuming that the norm was that it should revert to the sovereign in times of vacancy. Becket saw more clearly than many of his colleagues that the blanket denial of any clerical liability before lay courts was a simpler and safer policy for ruling out the dangers of a restraint of appeals to the curia. It's interesting that, conversely, we might say, the English crown's successful bid to secure its own interest and independence in ecclesiastical affairs in the 1530s began precisely with a statute in restraint of appeals in 1533, that's to say the freedom of appeal to the Curia, was the first target of Henry VIII in undermining the independence of the clerical estate. The hard line taken by Becket on clerical immunity, therefore, is bound up with this broader agenda. And it enabled him, as we've seen, to deploy the somewhat novel argument from double jeopardy, to deny clerical liability outside the clerical courts, and thus also to conserve the model of reformatory punishment as the distinctive practice of the Church. So really, this is what that phrase, saving our order, saving the rights of our order, really meant. That qualifying clause which so exasperated Henry II when added to oaths of episcopal compliance. Now, John Guy implies that Henry II was consciously trying to create a different sort of church, wholly subordinate to the royal mandate, anticipating his eighth namesake. But I'm not completely convinced about that. I think it's more likely myself that Henry II was opportunistically picking off a series of situations in which episcopal liberty would conflict with royal control, while still making conciliatory noises about customary freedoms being preserved, even if they had to be argued case by case, as Clarendon clearly suggests, with no standing permissions for, say, visits to the Roman Curia. So Becket's reluctance to compromise in any way about immunity reflects a canonical theological position in which the cleric's person is defined as being sacrosanct, in a way that makes case-by-case adjudications virtually impossible. Whatever the merits or demerits of a specific plea, whatever the seriousness of the specific offence, the ordained person is to be granted the presumption of an independent ecclesiastical trial and the grace of reformatory punishment. In Becket's eyes, only this absolutist position is seen as securing the crucial twin liberties of appeal and of freedom in disposing of property. And the difficulty for a lay legislator lies in the definition of certain subjects as persons who, in virtue of their office or order, are, as it were, to be regarded separately from any particular acts for which they may be responsible. Their actions are not available to be judged like those of others because of who they are in the clerical system. Well, the legal stalemate between Henry and Becket is, I'd say, of abiding interest because it brings to light some fundamental issues around law and actual sovereignty on one side and the very nature of criminal offence on the other, issues which are still of more than academic concern. As John Guy's biography repeatedly notes, as I've already reminded myself and you, Henry's legal agenda was not that of a modern constitutional lawyer or a defender of popular rights and liberties. He was in practice claiming a right to create law by defining what counted as custom. On the other side, Becket's claim effectively removed the cleric from routine civic obligation. The liberty of the Church was not simply a freedom to be judged on the performance of specifically clerical duties by specifically clerical authority, but a fencing off of any activity performed by a cleric from adjudication by lay authority, whatever the gravity of an offence or the seriousness of a tort. It was not a charter of impunity exactly, but because of its individualistic focus on the reform of the sinner, it took no account of what might be needed to satisfy the right of the victim. The pressure to secure the freedom of the Church as a corporate body with responsibilities wholly distinct from those of the feudal networks surrounding it, paradoxically produced a picture of moral and spiritual accountability, which was perhaps not individualistic in the modern sense, but oddly divorced from the imperative to model mutual nurture and accountability in the Christian community. The price of clerical immunity is an idea of clerical accountability, which ignores the lateral dimension. The cleric is answerable to God and to canonical superiors. It is not clear what their answerability is to an injured neighbour or community. The parallels with some aspects of the abuse scandals in several churches, especially the Roman Catholic and Anglican communities, are not hard to see. The nature of the cleric's person is the determinative factor. Their actions are to be weighed in the context of who they, institutionally and sacramentally, are, not so much as members of the body of Christ, but as office holders within a canonical polity. And this means not simply that they are to be judged on the performance of duties distinctive to their office, a perfectly defensible position, but according to the canonical status of their person. As we know with painful clarity after the revelations of the last decade and more, there has long prevailed a sense that the ecclesiastical superior's first duty is to the spiritual welfare, the emendatio, of the individual office holder. Penalties are conceived as penances, moving to a new area, retreat and isolation for a period. It's as if what has been broken is not so much the bond of trust between members of a single community, or rather in the modern setting, both religious and secular communities, but the obligations for which a cleric is responsible to a superior. So that what has to be restored is not a wrecked and destructive relationship, but a pattern of conformity to duties required. Now, I'm not, of course, arguing that the systemic failures of hierarchical churches in dealing with sexual abuse by clergy are explained by 12th century debates. But I would say that to understand something of how clerical culture in the Western Church has developed through historic arguments about the nature of law and punishment can illuminate the present landscape. What I've been suggesting is that a set of genuinely urgent and intelligible concerns about defending the Church's liberty in disposing of its property featured strongly in the emergence of a more intense focus on the clerical person as subject to a distinct kind of jurisdiction. The concentration on the penitential and reformatory purpose of punishment was not so much a general theory about penal ethics. After all, it wasn't generalized at all beyond the clerical state, as a way of indicating the need to hold clerics to a distinctive set of rules so that their own lives could be models of that reformatio in the divine image that was the purpose of sacramental grace. Some of you may recall the classic monograph of 1959 by Gerhard Ladner on the idea of reform, subtitled Its Impact on Christian Thought and Action in the Age of the Fathers. Ladner is dealing mainly with an earlier period, but his argument is that by the 6th century, the idea that the ordained male celibate had become the paradigm for restored or reformed humanity is quite deeply entrenched in both theological and canonical literature. The impulses of Alphege, Anselm, and Becket himself can't, I would say, be written off as entirely to do with institutional self-interest. The standing, especially of Alphege and Becket, in the popular memory suggests that their professed concern to preserve the Church's freedom to do what it could in the relief of the needy was not seen as a fiction. And as I've hinted, the rapacity of those lay magnates who took over the administration of Becket's properties during his exile certainly reinforced Becket's case. But the difficulties enter in when Becket and his intellectual allies conclude that the only watertight security for this aim lay in the blanket exemption of clergy from lay courts. It could be argued that the drawing of this conclusion reflects that increasingly dominant Western medieval habit of seeing the Church as primarily the body of those under clerical discipline, the polity of the ordained, rather than the community of the baptized. But the other side of the coin in this debate is, of course, the role of the Church as a body whose existence is not franchised by monarchical power in a society of diverse conviction and differentiated obligation. We might conclude that Becket was dangerously wrong in his absolutism about clerical immunity, and that behind this lies a theological deficit in the understanding of the Church itself, which was emerging in the 11th and 12th century movements of ecclesiastical reform. And yet, as we've noted more than once, the agenda of King Henry II was not an innocent legal universalism. The Clarendon Customs aimed to deliver into the king's hands the final say in ecclesiastical elections, canonical appeals, excommunication of any of the king's subjects, and the control of church finances, as well as, for example, requiring the consent of a feudal superior for the ordination of a candidate from a bonded tenant family, a villein family. In other words, all other obligations were to be trumped not only by feudal duties, but by feudal duties as adjudicated by the royal courts. That's to say, the goal of the king is not so much a system of equal legal redress for every subject of the crown, but a system in which the sovereign's definition of legal obligation is the context within which every other account of duty or responsibility had to be adjudicated. A unitary, absolutist concept of sovereignty, only very doubtfully qualified by precedent, was to prevail. The Church's objection that certain duties were owed unequivocally to God and the ecclesiastical authorities who controlled the penitential system was overruled. Well, 12th century England was not a society of religious or communal diversity in anything remotely like the modern sense. But the issue raised by the model of sovereignty I just summarized does cast a long shadow. It's easy to assume that if there is a single set of universal legal guarantees, protections, and obligations, this must extend to every area, not only of individual but of collective life, as if the only identity that ultimately matters is the identity of the legal subject. But in reality, of course, human agents are involved in various kinds of obligation of mutual guarantee. In families, in involuntary membership of voluntary bodies, in informal membership of voluntary bodies, in religious communities. A sovereignty that aims to draw all those networks of obligation and all those networks of obligation into a single structure is itself something of a problem. So I don't, in these reflections, want simply to demote the holy blissful martyr from his position to the level of a traitor to his prince in the style of Henry VIII's propaganda. But I do want to suggest that the harder we look at the precise issues of this controversy, the more we can see also the deep ambivalence, to put it no more strongly, of the particular tools used by Becket and his theological advisors to consolidate their resistance. Henry is advancing a model of sovereignty which overrides any conceivable kind of belonging, not franchised and licensed by the sovereign. Becket and his allies are right to see that as problematic, but their own response is problematic in its own way. If churches are to justify resistance to secular authority, or to make a credible claim for public recognition of both individual and collective religious conscience, they need to work at an ecclesiology rather less problematic than that advanced by Becket, or indeed most of the canonists who constructed the practice of the medieval ecclesiastical system. If some are worried about the sanction this appears to give in contemporary situations, what many believers regard as regressive habits or disciplines, It may even be that clarifying the basic ecclesiology of resistance, with an eye to purging it of the residue of the complex clerical self-definitions of medieval debates, can itself become part of that internal self-criticism which moves the church to change, not by compulsion, but by conversion. Thank you very much indeed for your attention. I believe we have some time now for question and discussion.
Well, Rowan, I very much hope we do. The difficulty with Zoom is we don't get the spontaneous applause for the sheer brilliance of your presentation, covering centuries of English legal history, dealing so authoritatively with the 12th century, and also giving the lie to that rather foolish notion that Becket is better known for his death than he is for his life. I very much hope that those listening from all over the world may wish to put questions or to comment and enter into dialogue. Christopher, can you be brought? Is that Christopher Hill? I've just recognized your Christmas jumper, Bishop.
Well, Rowan, I'd just like you to invite you to make perhaps a comment on what a distinguished Mirfield theologian, ecclesiologist and political commentator, Figgis, would have said. His work on the Church in the Modern State surely it comes into the latter part of your discussion, and wisdom on that would be much appreciated.
Thank you, Christopher. Well, mentioning Figgis, of course, you mentioned one of my great and authoritative sources. And in the fuller version of this paper, there is a footnote about precisely Figgis and churches in the modern state. For those who don't know, John Neville Figgis was a Cambridge historian and political theorist, a student of Lord Acton and F.W. Maitland in the late 19th century, who eventually became a member of the Community of the Resurrection at Mirfield. And part of Figgis's contribution, the genius of his contribution, I think, was already before the First World War, to be looking at questions of church and state, of the proper limits of ecclesiastical independence, challenging some of the Erastian ideas still around that in some sense the state should have the authority to determine internal church disputes. He wrote about some disputes in the Church of Scotland at his time, which had been settled in the courts and then had been decided to be unsettled in the courts. And I think he looked forward to a Church of England less dependent on the structures of the establishment as they had been, and more in accord with the notion of the free church and the free state that is sometimes referred to. So Figgis is an important presence in this, and he certainly does reflect on precisely how to hold the balance, which I was trying to reflect on in my last few minutes. That is the balance between the need to say the church must have the liberty to determine its own priorities, and the much more problematic version of that, which says the legal system never has the right to interfere in the liberties guaranteed to everyone, insofar as they're affected by church personnel. Figgis, I think, comes as near as anyone to holding that balance with real intelligence and acumen. So thank you, Christopher, for mentioning him. I'm always happy to talk about him.
Thank you also, Christopher, for being first off the mark, because you seem to have encouraged other people to overcome their shyness. And there are a rush of questions now in the chat box. Can I take two together? The first from Matt Rhodes, and then from Nicola Moxie. Russell, if we're able to bring them into the conversation, that would be ideal. If not, we can take the written question. But Matthew Rhodes, please.
Thank you so much, Lord Williams. It's good to see you again. The question I had, and I'm no ecclesiastical law authority by any stretch of the imagination, even as a priest, but I'm just wondering if the conflict between Henry and Becket over these issues was an acceleration of something that would have happened at some point already, and if it hadn't been these two individuals, when might it have been?
Thank you very much. It's a very good question, and I think the answer is indeed it's part of a wider story. As I said, it's a period when the church's self-definition as a body in some sense constituted and governed by codified law is really advancing by leaps and bounds. And of course, the result of that is that the potential for collision with other kinds of legal system is becoming sharper. I suppose that what accentuates it in England at this time, and it's England rather than Henry II's other realms, interestingly, that the issue doesn't surface in Henry II's extensive French territories. It's England. England is emerging from a period of chaotic civil strife. Henry is temperamentally an impatient person who wants to guarantee that the civil strife of the early generation does not recur. It's not an aim in which, of course, he succeeds, given his own chaotic family. And at the same time, Becket, temperamentally, is somebody not particularly given to compromise, but also, more importantly, he's surrounded himself with a highly sophisticated group of cutting-edge intellectuals like John of Salisbury, who are pushing, if you like, the latest continental fashions in theories about clerical immunity. So it's a crisis waiting to happen, and happens, I think, in England at that particular point because of those particular personalities and conditions. I'm not a professional historian, so I can't go into greater detail, but I think that's some of what's going on in the background. And ever since Beryl Smalley's great book on the Becket controversy in the schools, of course, we've been reminded that into Becket's ear is coming the latest stuff from debate in Paris and elsewhere.
If you take Nicola Moxey next, and then move to Elizabeth Jordan and Matthew Otley. And when we have all three questions, as brief as possible, please, Rowan can respond. Nicola Moxey.
Yeah, thank you. I very much appreciated your point about a conversion to canon law happening over time. And I was wondering whether there were any examples of religious preference still existing at the time of the Reformation.
Sorry, could you say a little bit more about religious preference? I'll just get the question clear.
I'm sorry, where the religious community was treated in a different way to the non-religious.
Okay, thanks, I'll come back.
If you hold that question, we'll go next to Elizabeth Jordan.
Thank you, because it is related. There are two things about the understanding of the ontology of priesthood at that time, and questioning whether there was a sense in which priests had to be treated differently from lay people because they were essentially different kinds of human beings. And just wondering if you could explain how that understanding had developed at that time. And then the question about the oath that a priest might make to the bishop, was that unconditional, or was that as now conditioned, all things lawful and canonical? Because that would seem to me to be inherently antagonistic if there was part of the population taking an oath. So I was wondering if you could explain those two things that really existed at that time.
And hold your answer while we move to Matt Otley for the final question of this clutch.
Good evening, Lord Williams. Thanks very much for the talk. So I was wondering really whether you see any parallels, if any, between kind of the issues of what Henry II seems to be trying to initiate in terms of the idea of sovereignty And today, with the increasing prevalence of kind of an overbearing executive and the trying to like Henry VIII powers and that kind of thing. Thank you.
Thank you. Well, I'll try to be brief then in my response to 3 very interesting questions. First of all, on the continuing special treatment, if you like, of church and churchmen, well, you could say in a sense, Becket might have lost the battle, but he won the war. The immunities of the clerical state remained generally pretty much entrenched up to the Reformation. And as I said, that is really why Henry VIII begins the Reformation, not with any doctrinal point, but with the statute and restraint of appeals. A cleric does not have the freedom to go over the king's head to Rome. And that's a very fundamental thing. So as soon as that changes in 1533, in effect, the king is saying, I am the bottleneck through which you have to go. You don't have any standing permissions to go round the royal courts. You can't just go and get another judgment from somewhere else. So it's very much part, if I can go to the third question, very much part of a theory of sovereignty, which is pretty monolithic. That is, there is in any polity, any country, there is one sovereign, one only, whose decision is final. And that's fair enough. You could say that's the whole definition of sovereignty, political sovereignty. But the much more interesting question from the legal point of view is what conditions sovereignty, what allows sovereignty to be something other than arbitrary. And you can deal with that in terms of sovereignty under the law. You can deal with it in terms of precedent. It's, of course, not unconnected with debates, very complex debates in the United States about originalism in terms of the Constitution and how that is read. But most political entities have a pretty good try at making sure that sovereignty is not just what the sovereign says it is. The sovereign may be a final court of appeal, but that court of appeal has to operate according to certain protocols that are not just up to the sovereign's decision. So I think a great deal of the political theory, political debate, not least political theology, has to come back again and again to that question of what is it that sovereignty works by, other than its own interests and its own self-definition. And I think Matthew's right in a way to say that wherever there is a trend towards an overdeveloped, sort of hypertrophied executive, that's an issue we have to be aware of. And one of the things that Neville Figgis, whom I mentioned earlier, was very interested in was how we understood the state, not as something simply standing in isolation over against the population, but the state as managing the relationships between a whole lot of intermediate or subsidiary communities where people's primary loyalties and primary identities could be identified. So Figgis talks about churches, universities, trades unions. He might as well have talked about other kinds of cooperative venture, credit unions or whatever, all the ways in which people organize themselves. And the sovereign power is not something which sweeps in and blots out all those intermediate levels. The sovereign power is the one that listens to, adjudicates, moderates claims as between existing identities and communities. So in a phrase that Figgis and others made famous, the state is a community of communities, not a sovereign power and a passive population. And I think that has a lot to say about the need for vigorous local democratic institutions, but that's another story. But turning finally to Elizabeth's questions, I think you put your finger on it in seeing the particular reading of the ontological difference of the ordained person bearing in mind that, of course, the ordained person in the Middle Ages was not just the priest, but anybody with any kind of clerical allegiance, right down through the minor orders. And as I said, Gerhard Ladner's book, an old book, but still, as I said, a powerful one, attempts to show that in an awful lot of, especially Latin literature, by around 550, 600, the assumption is that the model for distinctive Christian identity is the central paradigm is the male celibate, and thus the cleric, the monk very particularly. So the corporation of male celibates is a kind of self-defining thing. That's what lies behind the idea of the church as a municipality, a law-governed reality. It's what's behind the deep unease about clerical marriage in the early Middle Ages. Because if you start having clergy who have loyalty to their families and who can transfer their property to their children, you've got a problem in ecclesiastical terms. So I think that ontological sense is very powerful. It's not, of course, that anybody denies that the image of God is present in the laity and restored by grace. Certainly not, no such caricature. But nonetheless, there is something about the corporation of the clergy which has an utterly distinctive character to it, because it's easily definable in terms of the law that governs their state as male celibates. I'm sorry, Elizabeth, you asked me a second question and I've now forgotten it. Will you just remind me very quickly? If you can unmute yourself.
Yes, it was about the an oath of obedience.
That's right, sorry, yes. And my answer is I don't know the exact terms of canonical oaths in the Middle Ages. I would guess that, of course, it's obedience according to the canons, because the bishop is bound by the canons just as clergy are, so it's not a blank check. But I need to do some homework there.
Rowan, I'd like to press on and try and bring in three more. I want to bring in J.P. Holmes, then Jane Strands, and then Roger Wilson. If we can go to J.P. Holmes, please. You may not have spotted his question in the chat box because it was directed to me personally. But can we pick him up on the visual?
Oh, hello there. Thank you, Lord Williams. I was just wondering very quickly if you could say something about the role of the Holy Scriptures in this debate and what reference was made to them. And also, if you might say a little bit more about the principal advisors to Becket and to what extent the church was seeing him as being too liberal.
Thank you.
Can we then go to Jane Strands, which I think builds on one of the questions you were asked in the previous batch. So Jane Strands, please.
Yes, thank you very, very much for what has been extraordinarily stimulating. It's very interesting to be transported back to the context of a time 1,000 years ago, but we are all listening to words like sovereignty in a new context. I'm listening from France, but I'm British. I hear sovereignty all the time in Brexit debates. How do we take church and state lessons from the Middle Ages into our own time? And how do we deal with issues of clerical sexual abuse or church abuse in ways that have integrity and do not only protect the church? So there's a church state issue and a church governance issue for me in what I've been hearing you say this evening. Thank you.
And can I just graft onto that a question which was posed by Morag Ellis, Dean of Arches, who's asked that I rather rephrase it than go to her directly. And it seems to link with this issue of safeguarding and so on. and in particular, the issue as to the extent to which there was a claim within the ecclesiastical courts to exercise a full discipline over the laity, and whether that was regarded as a matter of significance. And then finally, in this little batch, I said I'd hear from Roger Wilson, and if he can put his question, we may then have the chance of having one further round of questioning before we draw this evening to a close. So, Roger Wilson.
Yes, yes, I've enjoyed it very much. I just wonder, Lord Williams, you didn't actually say much, I don't think, about the particular personalities involved here, and whether different personalities, situation might have been different. And I'm also interested in wondering whether things might have ended differently, might have, had Henry not gone as far as having his son crowned at the last minute.
Thank you. Right, well, let me see what I can do in terms of those questions. I'm taking the last one first. A lot could be said about personalities. I've already said a little bit in answer to another question about the particular constraints that I guess both Henry and Becket felt. And Becket was clearly regarded by nearly all of his bishop colleagues as both a bit of an outsider and a bit of a nuisance. And even those who agreed with him on some points didn't think he was much of a tactician about it. Becket was somebody who was very much in love with the dramatic gesture, as we can see from a number of aspects of his life. And when he knew he was going to die, as undoubtedly he did, he made quite sure that it was an appropriate drama. And I don't mean by that there's anything insincere about it, but he knew that he had to stage his last hours. And there's something rather moving about that, as well as something rather odd. He knew he would have to look and sound like a martyr, as he was. But yes, I think you're right. I think the king, doubtless with his own advisors, is being pressed to press the issue, and the coronation of the young king is a profound insult to Becket and to the privileges of the See of Canterbury, as Becket would have understood them. And the involvement of two of Becket's most relentless critics, Folliot of London and Roger Apollo-Becket of York, an appalling person, and the involvement of those two is a real provocation. It could have been avoided, probably. Certainly, it did not have to come to that point. And we see, as I mentioned in passing, we see that the papal court later in the 12th century, other jurisdictions sort of managed this without too much bloodshed. So there is that personal element. Anyway, to the other questions, if I can remember them. The first was about scripture, wasn't it? And about some of Becket's advisors. The role of scripture, I think, is an interesting one because, of course, it's at this period you also have developing a much more kind of tightly codified system of interpreting scripture, as it were, paragraph by paragraph, rather than more generally the so-called postile method. Postile verba, after these words, you add a little paragraph on interpretation. But I don't think that scripture figures very largely in this particular debate. People will, from time to time, of course, use Hebrew notions of the duties and privileges of the tribe of Levi as a way of defending the distinct status and privileges of the clerical order. And there is also that notion of the plenitude, the fullness of authority granted to the curia in Rome as an aspect of the fullness of the power of the keys, the binding and loosing power given to St. Peter and to the successors of St. Peter, which is, whether you agree with it or not, scripturally grounded in some way. So It's not essentially a debate about the interpretation of scripture, though that features in it. And as I said, Becket's advisors are people who've been through the incipient university system, especially in Paris. They are beginning to develop a lot of quite novel, very sophisticated ideas about law and about the nature of the church as a law-governed body. And Becket, who's not an academic, but who's a very, very receptive intellect indeed, Becket is happy to pick up on these things. And it's an interesting aspect of Becket's conduct as Archbishop, that he, it seems, quite deliberately takes promising scholars into his household as advisors. Herbert of Botham and John Salisbury are the two most frequently quoted examples. So he wants to bring that cutting-edge reflection from the schools of Paris into his household and into the debates he has. Then debates about sovereignty. Yes, what do we learn from that? I think, as I hinted a couple of moments ago, we probably need, and I'm putting my neck on the block a bit here, we probably need to be cautious about the way in which the word sovereignty is thrown around in debate, as it so often is these days. And to be, as I said earlier, cautious about thinking that sovereignty simply means the power of the state as opposed to the population. Sovereignty is a matter of being the final court of appeal in legal matters, but that doesn't mean that it needs to be proactive about that. It means it can be a system that genuinely nurtures and builds capacity in intermediate organizations, which encourages local democracy. And I would like to hear rather more about that than we sometimes do here. And in our present world, it seems to me that there are self-evidently quite a few matters where we will only solve our problems by real cooperative work in ways which might compromise absolute sovereignty. In other words, the freedom of every independent state to do exactly what it wants in every respect is not necessarily a freedom that's going to deliver us from pandemics or environmental crises or whatever else you like to think of. Not that anybody imposes a loss of sovereignty, but that there is a properly negotiated cooperation about sovereign power that's part of political health. And then the other issue for Morag was,
jurisdiction over laity.
Jurisdiction over laity. That's where actually the attempted restraint of the power of excommunication comes in. Yes, of course, the church claims disciplinary power over the laity, imposing ecclesiastical penance, certain ecclesiastically defined offences. And that's why the idea that bishops should consult the king before pronouncing a sentence of excommunication is, I think, reasonably enough regarded by Becket and his supporters as a pretty damaging concession. And of course, it has to do with the fact that Becket and others were using excommunication pretty freely to reinforce their own case, and Henry wanted to put an end to it. I forgot to mention the other issue that came up in one of the questions about how all this impacts on our understanding now of church and state and law, particularly in the context of the abuse controversies. And I wanted to at least touch on that in the main body of the paper, because it seems quite clear that while what the church believes and does is not dictated by the state, offences against the person, offences especially against the vulnerable, are properly, legally punishable, because the duty of the law is to protect persons against injury by others, whoever it's inflicted by. So I don't think there is really any argument about the rightness of the state's role in tackling the matter of abuse, violence, any other kind of grave criminality, which is what it is. And the sadness has been that what I call the long hangover of that idea of clerical immunity and reformatory punishment has weakened the church's credibility in response to these grave and shameful offences. So there's a lot could be said there, but I just leave that for you to reflect on.
I think time is against us, but there are two questions I think which might usefully act as closure for the Q&A. Father David Terwilliger, I will take first, and then Francis Gray afterwards, because these are each rather particular and focused questions. So David Terwilliger first, please.
Thank you very much. Greetings from Anchorage, Alaska, and where we're getting lighter at this moment, where you're getting darker as the daylight goes on. I wrote down my question. I don't even see it now, but it was to the effect of, I believe, how conscious was it in the 14th century at the development of the Statute of Provisors and Praemunire, this conflict between Henry II and Becket?
Thank you very much. And while Rowan reaches for his history book, Francis Gray, please.
Thank you very much for a very illuminating talk, Lord Williams. There were lots of echoes for me about sovereignty as you went along, obviously. And in today's context of the established church, I was wondering, in the context of your talk, how would you characterize Charles I's later discussions with Oliver Cromwell and the Commonwealth, and now with Prince Charles's declaration of becoming defender of faith, not the faith, as a constitutional monarch?
Goodness, well, I think both of those questions could take us the next hour or so, but let me tackle the historical one as best I can first. You're absolutely right, of course, to refer to the Statute of Praemunire as a kind of foretaste of the statute in restraint of appeals. I said earlier that clerical immunities and the privileges of the liberties of the English Church remained until the Reformation, but there were attempts to restrict this at various points. The suppression by Henry V of foreign-controlled monasteries was a step in that direction, all to do with an abiding unease in the royal administration, that there were bits of the feudal, financial, ecclesiastical network that were getting out from under their control and needed to be reined in. And of course, at times of war, when you're not only dealing with the emotional elements of international conflict, but with the financial need to find subsidy for armies, the idea that you really need to stop the holes, as it were, stop the leaks in the legal system, the financial system, that's very powerful. So you're quite right, it's not just Henry VIII. There is a legacy of Henry II's worries carrying through, which becomes quite marked in the first, at the very end of the 14th, the beginning of the 15th century, and then, of course, swells up again in the 1530s. A long story, but thank you for reminding me of that. And then, yes, the establishment, very briefly. It's interesting that, thinking of Charles I and Oliver Cromwell did try to resist the idea of an established church, even though there were plenty of non-Anglicans, plenty of Presbyterians, who wanted a Presbyterian established church at that time, as in Scotland. Cromwell did have some elements of a genuine belief in religious liberty. He didn't extend it, of course, to Roman Catholics, because Roman Catholics were self-evidently the enemy, and so he would never bother with them. But he did, I think, honestly want to see a different kind of polity from what had prevailed before. Not just Presbyterians replacing Anglicans, in the law, but a law which gave liberty of association, liberty of worship to a wide variety of Protestant bodies. And interestingly, that does seem to be a powerful conviction that he never wavered for all the pressure. So it's a fascinating bit of history. What we make of it now, I don't know. I suspect that Prince Charles's famous phrase about being a defender of faith rather than a defender of the faith was a soundbite he might live to regret, because I don't think he would himself want to challenge the idea that the monarch should be a communicant layperson of the Church of England, which is what it comes down to. Whether that requirement on the monarch is something that will survive indefinitely as we become a more diverse society is a moot point. But I think so long as the Crown does have a role in the administration of the Church of England, for good or ill, then the requirement that the monarch should be a communicant of the Church of England does make some kind of sense. But I say that as somebody who is now back in a disestablished church in Wales, and who therefore doesn't necessarily think that the sky will fall if we were not an established church. But that's, again, a long story. Thank you for raising it there.
Well, it's obvious from the chat box that there's a huge level of gratitude for your presentation and for taking such a wide variety of quite demanding questions at the end. So to close this evening's event, I'm going to pass to Professor Michael Morland of Villanova University, who I'm sure will speak on all our behalves in expressing our thanks to you. So, Michael.
Thank you, Mark, for your chairing this meeting. Thank you to the Ecclesiastical Law Society for its sponsorship, and especially to Russell Dewhurst for his magnificent work running the technology that enabled this to happen. I direct the McCullen Center at Villanova University, which is also a co-sponsor, and thank also to our other co-sponsors, the program on church, state, and society. At Notre Dame Law School, whose director, Rick Garnett, is on our meeting, and the dean and chapter of Canterbury Cathedral. We had at one time a hope that we would have a symposium of some kind in person in London to commemorate the 850th anniversary of Becket's martyrdom. There's also, I believe there is going to be a special exhibit at the British Museum and other events around Canterbury. Well, none of that could take place, of course, this year. But I think we did something even better. We had a magnificent talk here from the 104th Archbishop of Canterbury, one of the great Christian intellectuals of our age, commemorating this anniversary of the martyrdom of the 39th Archbishop of Canterbury. So, Lord Williams, finally, most of our gratitude goes to you. Thank you for this wonderful talk, and thanks to all of you for joining us. And with that, we are adjourned.
Thank you so much.